Child custody and parent time awards need to incorporate more humility. Many parents walk into family court hoping someone will finally fix everything. They hope the judge will see through the lies. They hope the evaluator will identify the real problem or problems. They hope the therapists can and will repair the damaged relationship. They hope the guardian ad litem will protect the child. They hope the court will create a parenting plan so detailed that future conflict becomes impossible. That hope is as understandable as it is unrealistic. Family courts have substantial legal authority. They can decide child custody disputes. They can set parent time schedules. They can allocate decision-making authority between the parents. They can order child support. They can impose consequences for misconduct. But courts cannot order trust. They cannot order affection. They cannot order respect. They cannot manufacture healthy family relationships. This is not a criticism of judges. It is reality. The problem is that modern family courts sometimes behave as though they can engineer families. Presented with conflict, they often layer intervention upon intervention. Therapy, counseling, reunification counseling, parenting coordinators, custody evaluators, guardians ad litem, review hearings, behavioral directives, and increasingly complicated parenting plans. Sometimes those tools help, but often they create more expense, more confusion, more professional involvement, and not much more peace. Therapy and counseling can help people who need it, but therapy or counseling is not a substitute for parenting, accountability, evidence, personal responsibility, or judicial decision-making. Not every upset child is psychologically damaged. Not every strained parent-child relationship, especially at the time of divorce, requires clinical intervention. Not every parenting problem is a mental health problem. At some point, repeated referrals to counseling and therapy stop looking like solutions and start looking like a way to transfer an unsolved problem from the courtroom to the therapist or counselor's office. The burden often falls hardest on children. Children in high conflict or even low conflict cases these days can find themselves constantly observed, interviewed, evaluated, treated, analyzed, and managed by adults who all claim to be helping. Sometimes they are helping. Sometimes the child has simply become the project. Courts also tend to favor complexity. The assumption is that more rules will mean less conflict. But parents who want peace usually do not need a 50-page parenting plan. Parents who want conflict can create conflict under any plan. Every extra rule creates another opportunity for accusation. Every additional professional creates another source of competing opinions. Every layer of complexity can become renewable litigation fuel. Family courts need more humility. They should resolve disputes fairly, insist on evidence, hold parents accountable, enter clear and enforceable orders, and treat parents and children with dignity. That may sound modest, but is the most any court can realistically accomplish. And in many cases, it is enough.